Hey everybody. I just wanted to make a quick video on the new, I guess, FINRA and Wells Fargo scandal that's come to light. This is actually from a couple months ago, but recently it's been getting a lot of attention, um, probably because of what you can see here. So this is a tweet from Senator Warren and Katie Porter. So they both, I guess, they're both tweeting at FINRA, and they said Wells Fargo has been caught cheating consumers too many times. And in this case, they were caught rigging the arbitration process to escape accountability for their actions, and FINRA let them. Rep. Katie Porter and I want answers from FINRA. So essentially, this is actually a really big deal. And I think it's great that they're bringing to light on it. Is anything going to come of this? Like, who knows? It's Congress. Like, they've never really been able to kind of get the ball rolling. Like, I mean, we all remember the GameStop saga that happened last year when Congress just like allowed Ken Griffin to lie to them to their face. But let's explain what's happening here. That's besides the point. So, real quickly, what is arbitration? So, when instead of going to court with someone, right? So instead of like suing somebody and going to court or going through mediation, you can both mutually agree to go through arbitration. And there's a couple benefits to going through arbitration as opposed to like litigation, going to court, right? So litigation can be expensive. Also, when you go to court, the case information is public, right? There's public records of all those things. So um, in arbitration, you can both choose to keep things private if you want to. And then also, going to court can take years. Like, it can take forever. You hear about it all the time. People go to court and they're like 10 years later, they're still going through the process, right? So in arbitration, the reason that this is different is that um, in arbitration, a neutral third party or an arbitrator is selected to oversee the case and determine the outcome. So the arbitrator, in essence, serves as a private judge and is responsible for determining who wins the dispute. So by going through arbitration, both parties are choosing to accept the ruling of this quote unquote private judge, right? So they're saying we don't want to go to court because it's this long, expensive thing. Let's just go through arbitration and try to handle this kind of under the table, quietly and quickly. So that's what's occurring here. Um, and so the most important part about this is that the arbitrator must be neutral, a neutral third party, right? They cannot be involved. They have to be completely impartial. And that is the process here that FINRA and Wells Fargo broke. They both played their part in making sure that the arbitrator was not a neutral third party. So let's go over what happened here really quickly. So this was from Barron's on February 4th. So in 2017, Brian Leggett, I hope I'm saying that right, apologies if not, but Brian Leggett, a Wells Fargo customer, filed an arbitration claim against the bank and one of its financial advisors, accusing them of negligence and breach of fiduciary duty and how they handled his investments. So that's his claim. An arbitration panel ultimately ruled against him, so he lost, and issued an award in Wells Fargo's favor, ordering Leggett in 2019 to pay $83,000 to Wells Fargo to cover its costs. So they went through arbitration, he lost, um, and he now has to pay Wells Fargo $83,000. So fast forward to this January, when a Georgia state judge has not only vacated the award, Leggett was ordered to pay, so he doesn't have to pay that anymore, and also accused Wells Fargo of withholding evidence, stonewalling document requests, and unfairly tilting the arbitration process in its favor. So this is a really, really big deal. The judge says the firm committed fraud on the arbitration panel by procuring perjured testimony, intentionally misrepresenting the record, and refusing to turn over a key document to the investor until after the close of evidence. And this was Judge Belinda E. Howards, and she wrote this in her ruling. Um, Judge Belinda E. Howards, bless your soul. Just really well done on your part. So Lisa Braganza actually she did a really good write up on this on February 2nd. So a couple days before this Barron's article came out. And I'll link this in the description. I'm going to go over kind of some of the bullet points here, but she did like a full breakdown of what happened, um, and of what Belinda Edwards said, kind of about the case, like how this judge came to that ruling. This is what Lisa's going over here. So let's go over it just really quickly. Um, so first, there's manipulation of the arbiter selection process or arbitrator selection process. So this is a big one. So FINRA represents. So what they say. Remember, FINRA is an SRO, right? So they represent that it has a specific process for the selection of arbitrators that randomly generates a list of potential arbitrators that are sent to the parties for review, striking, and ranking. FINRA represents that it is a fair process by which the parties may select a panel of arbitrators to decide their dispute, right? So FINRA is saying that this process is fair. Well, that's a lie. What FINRA does not tell investors is that it sometimes removes potential arbitrators from the supposed quote unquote neutral and computer generated list. That's very clearly a lie. At the request of brokers' attorneys. So the case reveals that Wells Fargo's attorney had a secret agreement with FINRA that certain arbitrators would not appear on the list of potential arbitrators. So what's happening here is, let's say I'm suing Wells Fargo, or I'm going to arbitration through Wells Fargo. Now we have to find our neutral arbitrator who's going to decide the outcome of our disagreement. Well, Wells Fargo and FINRA, they have an under the table agreement that Wells Fargo gets to cherry pick who the arbitrators that are going to be decided between are selected. So let's say there's 10 arbitrators. Wells Fargo gets to come in first and say, okay, well, we don't want this one, this one, this one, or this one, but the rest of these we're okay with. So go ahead and show that to both parties and let's select from here. Like this is completely fraudulent and broken. So that's the first thing that happened here. And by the way, this isn't this isn't a question. Like this is what the court found to be true. This happened. So what's the next thing here? Refusal to postpone hearing for good cause. So the court found that the arbitrator's denial of the investor's request for a short postponement when Wells Fargo produced a significant number of documents just days before the beginning of the evidentiary hearings was a violation of the Federal Arbitration Act. So what does that mean? So Wells Fargo produced a ton of documents, and instead of giving Mr. Brian Leggett and I'm assuming his team time to go over these findings, the arbitrator said, no, you don't get a short postponement. We're not going to give you time to go through these things. Let's go ahead and just let's start the show here. So like that in itself, that's messed up, right? Refusal to hear relevant evidence. And by the way, guys, like I really encourage you, I'll link this blog. Come read this because these are all screenshots from, what's the judge's name? Judge Belinda E. Edwards. These are all screenshots from her oversight of this case, or her overseeing of this case. So the court found that the arbitrator's refusal to hear relevant non-cumulative evidence from the investors relating to two of their main claims and in response to evidence introduced by Wells Fargo. So like this one is crazy. So um, the arbitrators here, so essentially, what's his name again? Brian Leggett. Brian Leggett, he has evidence that's relevant to two of his main claims. And the court is saying, the arbitrators are saying, no, we're not going to listen to the testimony. It looks like they refused to hear testimony from two separate witnesses, each of whom had relevant non-cumulative evidence relating to the main claims asserted by the investors. So the investors were talking about Brian Leggett. So like that's crazy. Like there's evidence to be brought forth, and they're saying, no, we don't want your evidence. Okay, cool. Great. Good job, FINRA. award procured by fraud, perjury, and improper evidence. So this is a big one. So the court found that key witnesses used an unexplained medical delay that the broker firm. So when we say broker firm, we're talking about Wells Fargo. The court found that key witnesses used an unexplained medical delay that the broker firm obtained to materially change testimony, and that the attorney for the broker firm, Wells Fargo, quote unquote, inserted himself as a fact witness and purported to testify to the panel himself to support the change story. Like, this is ridiculous. The attorney that's representing Wells Fargo is now testifying on behalf of Wells Fargo. Like, what? I'm sorry, what? Um, Also, the investor did not have a transcript when the hearings resumed, so brokers' attorneys mischaracterized the broker's earlier testimony, and the arbitrators bought it. Like, okay, moving on, because we're still not done. Uh, Unauthorized award of cost, fees to broker slash fees to Wells Fargo. So the court also found that the arbitrators exceeded their authority in awarding Wells Fargo over $50,000 in fees and costs to be paid by the investors. So that's investors. We're talking about Brian Leggett here. The arbitrators are now charging Mr. Leggett more to cover the court fees that were already fraudulently earned. So it's like, not only are they lying about the case as a whole, but they're making him pay more than he should have to pay. Like, this whole thing is absolutely insane. So in this case, and this is kind of Lisa's final thoughts on this, she says, in this case, even though the court vacated the FINRA arbitration award because of fraud, the investor must still wait years to get justice. Vacating this arbitration award means that the investor has to go through this entire process all over again, from selecting a new arbitration panel, discovery motions that delay the evidentiary hearing, and ultimately an evidentiary hearing. It is more than ironic that I became aware of this decision on February 2nd, Groundhog Day. The investor is going to have that very same experience. So they have to go through this all over again. This link is the Barron's article that I linked before. So, um, what's the skinny of this? Well, the skinny of this is that FINRA is supposed to be a financial regulatory body that we the people can trust, to be fair and unbiased, right? If we have a case that has to go through FINRA, we want to make sure that FINRA is a neutral party in this. But what's occurring here is that not only is FINRA not a neutral party, but they are helping. In this case, they're helping a giant bank, Wells Fargo, beat the little guy. They're helping Wells Fargo fraudulently win against Brian Leggett. Like, this is a big deal. So now we have to ask ourselves, and by the way, this is the release that FINRA put out about this. I'll link this. I highly recommend you read it. Um, but we have to ask ourselves, so in this case, it was proven that FINRA fraudulently affected a an arbitration case. They lied about this. They broke the trust of the public in how their arbitrators are selected. They helped Wells Fargo win this case. We have to ask ourselves, how many times has this happened? How many times has this happened in the past? How many people have lost? I mean, Brian Leggett here almost lost $83,000. And I would imagine that that's probably a relatively small fine compared to some others who've been involved in this kind of process. But how many other people have lost? So if you have gone through an arbitration process against FINRA, and if you feel that that process was unfair or maybe needs a second look, I would highly recommend seeking counsel and talking to an attorney about this, because it's proven here that FINRA is not neutral and they are rigging the system against you. And they did it here to help Wells Fargo. So I thought you guys would enjoy this. This is, again, this came out a couple months ago, but now it seems that Congress is getting involved in it. So hopefully something happens with this. And guys, if you want something to happen with this, tweet at Elizabeth Warren, tweet at Katie Porter. Let's make sure that FINRA and Wells Fargo are both held accountable for this. Thanks for your time. Thanks for learning about this. And if you have any questions or concerns, go ahead and throw them in the comments below, and I'll try and answer what I know. Thanks for your time.